Should we get started, do you think, Sharon?
Sounds good.
Okay. Welcome, everybody. Today we have a presentation by Sharon Kamowitz, HIPAA Business Associate Requirements, the best practices for covered entities and business associates. Sharon, if you want to go to the next screen, we'll let people know a little bit more about you. And I think we all know from HIPAA huddles, Sharon has given us much knowledge in the past. She's an attorney and certified privacy official or professional, excuse me. And with that, just a couple of housekeeping items. We are recording the program, so you will get a copy of that at the end. And we are going to be holding questions until the end of Sharon's presentation. So if you want to submit them to me on the chat, that's fine. And I'll present them for you. Or if you want to wait till the question slide comes up and we open it up for questions, you can present your questions yourself. So either way, Sharon and I have determined that we will not fight for time or fight for who's going to get to talk. So with that, Sharon, thank you very much for your time and your knowledge. And here we go.
All right, thank you. Nice to meet you all, or virtually see you all for this presentation. Thank you, Cheryl and Sarah and Bethany and all the folks at HIPAA Track for inviting me to speak with you this afternoon. Just as a quick way of background, as Cheryl said, I'm an attorney and I'm a certified privacy professional through the International Association of Privacy Professionals. And I established a consulting practice back in January of 2020 after 20 years in-house in healthcare and insurance. And what's interesting about my background, and unusual a little bit, is that I've worked on both sides of the HIPAA fence. I've been on the covered entity side at Fresenius Medical Care of North America, which is a large healthcare company specializing in renal disease, but it also has some business associate functions. And before that, I was director and associate general counsel of Coveris, which is a medical professional liability insurance carrier based here in the Boston area. And it was a business associate. So I've been involved in HIPAA work since, before HIPAA privacy rule went into effect. So about 20 years. So hope to share a little bit of what I know. We're going to talk about business associate requirements, both from the covered entity and business associate side. We'll talk about business associate agreements, some common contracting issues, the importance of managing the contracting process, policies and procedures for business associates, and then what can go wrong, breaches and OCR enforcement. So as most of you know, covered entities are directly subject to HIPAA. And this is the healthcare providers, health plans, healthcare clearinghouses. And one thing about covered entities is that they must be in the United States. HIPAA does not regulate any healthcare providers, health plans, or clearinghouses outside of the United States. But for business associates, your business associates may be located outside the United States. So simply by being offshore does not get them out of the purview of HIPAA. HIPAA indirectly affects the business associates of the covered entities through business associate agreements. And a business associate is a person or organization that on behalf of a covered entity, and that's a key provision, performs, creates, receives, maintains, or transmits PHI for a purpose involving the use or disclosure of PHI, or provides services to a covered entity that involves the use or disclosure of PHI. So I think that it's a lot of words here, but I think the important thing to remember is that it has to be on behalf of a covered entity or services to a covered entity. So if an organization receives PHI, or what would be PHI if it came from a covered entity, but it came, say, from the patient directly, or through an app or something like that, that's not connected to a covered entity, it does not create a business associate relationship. So there's some differences in the way PHI can be used and disclosed depending on whether an organization is a covered entity or a business associate. As most of you know, a covered entity can use PHI for treatment, payment, or healthcare operations, commonly known as TPO purposes, pursuant to a patient's written authorization, or for certain public policy reasons, for example, law enforcement or public health activities, or pursuant to a business associate agreement. A key difference with a business associate, however, is they can only use or disclose PHI as specified in the business associate agreement. So if the business associate agreement doesn't allow, say, for example, de-identification, the business associate cannot use it for that purpose. And we'll get into that a little bit more when we'll get into the contracting discussion. So business associates, as I said, fall into two buckets. They can either create, maintain, transmit PHI on behalf of a covered entity. I mean, these are examples of these are on this slide. I'm not going to read them all to you, but it's things like claims processing, quality assurance, patient safety activity, billing, because these are all services that are performed on behalf of the covered entity. And the other category is providing services that involve the use of PHI. So, for example, legal, actuarial. My work in a medical professional liability insurance company was providing a service that involved the use of PHI for the policyholders. So that's why there's two buckets of opportunities to become a business associate. Some examples of common business associates are, IT or software service providers, cloud or physical storage providers. And this is an interesting grouping because whether they're a cloud provider or a physical storage provider, they're still maintaining that PHI. And that's why it's critical that they be recognized as a business associate. EMR vendors, document shredding companies, legal counsel, auditors, accountants, etc. Direct mail vendors is one that's often missed. Collection agencies because they're getting PHI for collection billing purposes, or data analysts. And these are just some of the examples. HIPAA is very specific about who is not a business associate. So employees and other members of a covered entity's workforce are not considered business associates. Similarly, healthcare providers, device companies, or caregivers, if they're receiving PHI for treatment purposes, and it's for treatment purposes only. So we'll talk about that a little bit more in terms of the medical device companies. Similarly, health plans that are receiving PHI for payment purposes or reinsurers to the health plans would not be considered business associates unless they're doing some other service for the covered entity. And research is a carved out exception because they're not technically providing a function or activity on behalf of the covered entity, even if the covered entity engages the researcher to do the research. But OCR and the HIPAA rules specifically carve that out. There's nothing prohibiting entering into a business associate agreement for a research purpose, but it's not required. In addition, persons or organizations that may have inadvertent contact with PHI are not considered business associates. So an example here are janitorial services, which makes sense because their purpose of the relationship is not to maintain, receive, process, transmit PHI. They may have contact with, especially in a hospital, they may see a patient chart, but they shouldn't have access to it. So it would only be inadvertent. If you're working in an office, when you have proper security controls in place, you don't have PHI sitting on your desks, You've emptied your shredding containers into the shredders, and the janitorial service providers shouldn't ever see the PHI. But if they do, it would not make them a business associate. Telecommunications relay services are specifically carved out, as are conduits. And conduits is an area that tends to cause a lot of confusion. United States Postal Service, FedEx, UPS, et cetera, taxi drivers that are delivering a package are transporting the PHI, but they don't access or store it. What's interesting also is that an email provider would be considered a conduit, putting aside the whole question of whether your email is secure and encrypted and whatnot. But the cloud service providers are considered business associates because they're storing and maintaining the PHI, not just transferring it. query whether the email providers are also storing information, but that's a question for another day. And keeping in mind that the HIPAA privacy rule, as I like to remind people, went into effect in 2003. So there's a lot of things that may need some updating now that we're in 2021. So we talked about getting a business associate agreement. And I assume many of you know that a business associate agreement is a written contract, and it has required provisions that provide satisfactory assurance that the PHI will be appropriately safeguarded. And as I said, by signing the business associate agreement, a business associate takes on many of the obligations under HIPAA and can only use and disclose the PHI as provided in the BAA. The business associate agreement will set out requirements for the business associates to provide information to covered entities and respond to patient access requests as applicable. It has to be addressed in the business associate agreement, and that will depend on the nature of the relationship. Under HIPAA, a business associate must also enter into what is called a subcontractor agreement or a downstream BAA when it enters into a service agreement through which its subcontractor will do all the things that the business associate had agreed to do on behalf of the covered entity. So it's basically, think of it as a chain where the obligations go downstream to the subcontractor. So there's some complicated cases, and there's a lot of confusion about whether organizations need a business associate agreement. A lot of healthcare providers take the position that they just, that they push out these business associate agreements to all their vendors, whether it's required or not. And then some of the organizations sign them. Some of them have a policy to push back. It is a complicated area, and I always recommend that people consult with their legal counsel for any questions. Medical device companies is a common area of confusion. So as I mentioned before, if you're sharing information, if a healthcare provider is sharing information with a medical device company for treatment purposes, there's no need for a business associate agreement. So, for example, a technical representative from the device company is in the surgery suite to help train the surgeons on the new equipment. That would be considered treatment, and no BAA would be required. But if they were doing other services on behalf of the covered entity, so for example, they're estimating the cost savings from the use of a device, that's not treatment purposes, and therefore a business associate agreement would be necessary. Some other reasons why you wouldn't need a business associate agreement with a med device company are to help them comply with FDA reporting requirements for certain clinical research, if there's an authorization or partial waiver from the IRB. Another complicated case has to do with mergers and acquisitions. And as we all know, there's a lot of consolidation going on in healthcare, and there has been for a number of years. So if you are engaging an advisor, if you're a healthcare provider and you're engaging an advisor, like an attorney or a banker, an accountant, financial advisor, yes, you do need a business associate agreement. But there's no need for a business associate agreement between the prospective seller and the prospective purchaser, because they're not doing anything on behalf of the covered entity. Again, you would probably want a confidentiality agreement as part of your due diligence, but from the HIPAA perspective, you wouldn't need a business associate agreement. But in these situations, you do need to pay attention to the minimum necessary rule. So generally, even if you have a business associate agreement in any situation, you should be disclosing only the minimum necessary information if you're a covered entity to satisfy the requirements. And similarly, if you're a business associate with a downstream subcontract arrangement, again, consider the minimum necessary rule in all cases. So this business associate agreement contracting issues are also, I'm going to give you a lot of words here, so I hope I don't lose you in the process here. There's certain requirements that every business associate agreement must have. So they have provisions regarding uses and disclosures, safeguarding PHI, reporting breaches, and contractual and regulatory obligations. Then there's other provisions that may or may not be in a particular agreement, depending on the nature of the relationship and what the business associate is being contracted to do. Some aspects of the mandatory provisions may be negotiable, And there's also some optional provisions, which again will depend on the nature of the relationship, and these two are negotiable. So first off, there's the mandatory provisions regarding use and disclosure require that the business associate use and disclose PHI only as permitted in the business associate agreement or as required by law. The business associates must comply with all relevant requirements of the privacy rule if the business associate carries out the covered entity's obligations. So if this is, say, responding to patient access requests or other obligations that are primarily those of the covered entity, then the business associate needs to comply with the privacy rule and have privacy rule policies and procedures. And we can talk about that a little bit more later in this presentation. The business associate agreement must require that the business associate use and disclose the minimum necessary amount of PHI, as I mentioned, and disclose PHI to assist help the covered entity comply with its patient's access requests. This, as you all know, is a high focus area for OCR right now. So this may be an area more for business associates as well going forward. And the BAs must require that the business associate mitigate any harmful effects of improper use or disclosure that it knows about. Now, depending on the nature of the relationship, the BAs may have other provisions. So, for example, to use PHI to provide the underlying services. And again, that's going to depend on what those services are. Use PHI internally, the business associate's own proper management, excuse me, and administrative services, or to carry out its legal responsibilities. Similarly, disclosing to a third party to provide data aggregation services, if that's a part of the relationship, or to create de-identified information or a limited data set, again, depending on the nature of the contract. To make sure I didn't miss anything. Okay. The business associate agreements must also have mandatory provisions regarding safeguarding PHI and reporting potential breaches. These have to do with notifying the covered entity and returning or destroying PHI, or limiting use or disclosure if return is not feasible at the end of the relationship. In addition, there's mandatory provisions regarding contractual and regulatory obligations. So the business associate, again, as I mentioned, must ensure that its subcontractors enter into the same restrictions and conditions, and the business associate must agree to cooperate with HHS, which is an interesting thing because it therefore pulls the business associate into HHS's regulatory overview. There's also some optional provisions that can be in a business associate agreement, but don't need to be. First is indemnification of the covered entity in the event of a breach. And for those of you who are not attorneys, indemnification is basically the business associate would be paying the covered entity's costs and losses. It may have insurance requirements in terms of what the business associate is required to carry. They're depending again on what the business associate is doing. They may need to the business associate may be required to comply with the covered entity's notice of privacy practices. There's options to include automatic amendments. So if HIPAA changes, you don't have to renegotiate all your business associate agreements. And provisions regarding standard transaction sets if those are relevant. So, as I said, often organizations will just sign business associate agreements without looking into what those provisions are. But there's a lot of negotiation leeway, as I mentioned. There's optional provisions, there's mandatory provisions, there's discretion in how you handle these things. So I would look at these as part of your whole contract process and not just a check the box exercise. So just for example, a common negotiating issue has to do with breach reporting timeframe. So for example, as you know, covered entities need to notify the patients within 60 days of notice of a breach. And they need to report to the OCR within some period of time, 60 days if it affects 500 or more individuals. So what do you put in your business associate agreement? If the business associate has 60 days to notify the covered entity, how is the covered entity going to meet its obligations? But if you're on the business associate side and the covered entity wants you to notify them 10 days after discovery, how are you going to do a complete investigation? So that's often a negotiating point between the two parties as to what's feasible given the organizations. And also, when you're looking at breach reporting, you always need to remember state law issues come into play as well. So if you're dealing with California residents, for example, HIPAA may allow 60 days, but California may allow 10 days for medical information. Another negotiating issue is who's going to handle requests for patient access amendment or accounting for disclosure. The business associate may have those records. Who's going to respond to the patients? Is it the business associate? Is it the covered entity? Again, and what time frame is going to be required for those responses? Another area of negotiation has to do with the liability and indemnification. And this is often done in the context of a service agreement, because a service agreement itself may have provisions regarding liability indemnification. But in terms of the HIPAA breaches, in HIPAA liability, many business associates say, well, I'm getting paid $100,000 for this contract. I'm not going to be liable more than the total amount that the covered entity is paying me. Why should I be on the hook for a $500,000 loss if you're only paying me $100,000? So that's a negotiating point. There could also be a cap on a liability for the breaches unless it's caused by a failure to follow agreed upon security protocols. So for example, I'm a business associate. I did everything I promised I would do. My security was tip top. Everything was fine. I still got hacked. There was human error. Something happened. Is there a cap that's different if I failed to follow my security protocols versus if I did everything the way I was supposed to do? Who's going to pay for the cost of notifications, credit monitoring, mitigation steps, other consequential damages? Those are all things that can be negotiated. Similarly, insurance requirements, as I mentioned before, some business associate agreements require that the business associate carry cyber coverage or technology errors and omissions coverage. But what's the limit size? If I have a $5 million limit policy, but I have 10 or 50 contracts going on, I'm a business associate, and I get hacked, those aggregate limits are going to be eaten up if it affects all my customers. So those are all negotiating points. And I think an important thing here is to know what you're signing. So as I mentioned, a lot of organizations look at business associate agreements as a check the box exercise. They sign them. They may get filed with their contract. They may be dispersed across a wide organization. And just as contract management is good practice for all organizations in general, knowing where your business associate agreements and who you have them with is critical. If you were to have a breach, you wouldn't want to know what the obligations are on both sides. I think for covered entities, make sure you communicate with your operational and legal teams and know what you're engaging the business associate to do. Determine how you want to approach these optional provisions. Do you have a template of your own, or are you using the business associates template? Again, that a lot of times this comes down to who has the leverage in the relationship, the big player versus the small. Consider all those agreed upon timeframes. Loop in your business people. What is practical, and make sure you know your regulatory deadlines, and then maintain an inventory of all your BAAs. If you're on the business associate side, again, make sure your sales team isn't overpromising and you know what the sales team is promising can be done, and loop in your legal teams. Again, determine your approach to your optional provisions. Consider whether you as a business associate want to lead with your own template agreement. Again, know what you have agreed to. You may have different contracting relationship with different customers, with different covered entities, where you've agreed to different timeframes, and now you have a breach, and you need to know, do I have to respond to notify them in 10 days, or do I have 60 days? And make sure you have a method to track that. And then similarly, when you enter into any subcontractor agreements, make sure you know what timeframes you've agreed to with the covered entity, because it's, as I said, it's a trickle down. So we've talked about business associates and covered entities and the differences, and we've talked about agreements. Let's move on to policies and procedures. So for business associates, privacy rule policies and procedures are optional, except if they're actually processing information on behalf of the covered entity. Remember, I mentioned that one loophole before. Nonetheless, it is generally recommended that a business associate have privacy rule policies and procedures. It's the best way to ensure compliance with your requirements and to avoid OCR enforcement. And before you think it's a huge headache, business associate policies and procedures in the privacy rule are a lot less complicated than those for covered entities. Generally, you would not need to worry about a notice of privacy practices. You don't need to worry about all the provisions for authorizations, personal representatives, certain other disclosures, disclosures to family members, and whatnot. So they can be fairly streamlined, and they're good practice to have. Security rule policies and procedures, however, are required if the business associate is obtaining ePHI, electronic PHI. In addition, the business associate must conduct a HIPAA risk assessment and analysis, implement the technical state safeguards, as I said, the policies and procedures, and are also required to have security training under the HIPAA security rule. The breach rule policies and procedures, people always forget about the breach rule, think it's either part of the security rule, part of the privacy rule, but it is a standalone rule under HIPAA. Security incidents must be addressed in the HIPAA security rule policies and procedures. Breach notification of paper records and oral information can either be covered in a privacy rule policy and procedure or in an incident response policy, but make sure that your organization, if you're a business associate, has a procedure that's documented to deal with any potential breaches of PHI. So, all right, we'll turn to what can go wrong, OCR enforcement. Now, when HIPAA first came into effect, there was a lot of discussion on whether business associates were liable for compliance. And the position was that business associates were contractually liable for compliance, but that the OCR could not enforce the HIPAA rules. That changed with the HITECH Act of 2009, and it made it clear that business associates are directly liable for compliance with certain aspects of the HIPAA rules, and those are the provisions that I've been talking about, and that OCR has the authority to bring enforcement actions against the business associates. So we'll go through just a few examples of what can go wrong for business associates and covered entities in this whole process. So this was a case from last year. This was a business associate that provided IT and health information management services. And there was a hacking incident exposing the PHI of over 6 million individuals. So as many of you know, once OCR gets in the door, they do, excuse me, a complete review of the HIPAA practices. And they found lots and lots of things in this business associate's business. Longstanding noncompliance, failure to respond to the security incident, mitigating its effects, failure to conduct a risk analysis assessment, failure to have certain security rule policies and procedures. And this resulted in a $2.3 million fine and a 2-year corrective action plan. Another example on a smaller scale was the Catholic Health Services of the Archdiocese of Philadelphia. And this was, again, a business associate providing management and IT services to nursing homes in this case. This case was not a hacking incident. This was a theft of a mobile device that wasn't encrypted or password protected. And unfortunately, these cases are still going on with these thefts of devices. So please make sure you're encrypted or password protect your devices and you know where your devices are. But that's for another discussion another day. In this case, the theft of one mobile device resulted in a $650,000 fine to the business associate. OCR found that they failed to have certain security procedures, again, in this case, addressing mobile devices and reporting the security incidents, and once again, failure to conduct a risk analysis and assessment. But not to be undone, covered entities can also get in trouble for failure to have proper processes for engaging business associates. In this case, Advanced Care Hospitalists last year, this is a kind of funny case because they engaged the services of an imposter who posed as a representative of a medical billing company. The imposter allowed the exposure of PHI of 400 patients. But what OCR had authority to enforce was the Advanced Care Hospitalists failed to enter into a business associate agreement with this imposter, which is kind of a funny situation. They did not have a policy regarding business associate agreements in general, and they failed to conduct a risk analysis and assessment. So, a certain lesson here is to make sure to do your due diligence on your prospective business associates, because in this case, they may have been able to avoid not only the breach, but also this $500,000 fine and 2-year corrective action plan. And then finally, this was the Center for Children's Digestive Health a few years ago. It was a nonprofit healthcare provider. They had a storage vendor that they did not enter into a business associate agreement with. Interestingly, the storage vendor, OCR, looked into the storage vendor as well, because he said, why didn't they go after the business associate? During the course of the investigation, the storage vendor went out of business. So that's why this was only an enforcement action against the covered entity. But still, it resulted in a $31,000 fine and a 2-year corrective action plan. I put up here some additional resources. As many of you know, I think it's always good to highlight, OCR has a lot of good information on its website. So, take a look at that guidance. The FAQs and guides are always very helpful out there. And I'm available for questions, as I'm sure the folks at HIPAA Track are. So I will, that is the end of the formal presentation, and I would be happy to answer questions that you may have.
Hi, this is Cheryl. Sorry, I'm doing the unmute thing not very quickly. Let me see if I can Michael, can I get you to unmute and present your questions, please?
Sure thing. Sure thing.
Thank
Hi,
you.
Sharon.
Thank you.
Hi, Michael.
Thanks for a great presentation. Hey, is my mic okay? I've been told that I sometimes sound terrible when I come into these Zoom meetings. So, okay. Sharon, thank you very much. I have a bunch of questions. I don't want to dominate the Q&A, but here's my most important one. When we do a HIPAA risk assessment, we always do an inventory of all of the business associate agreements. I know that it's sort of outside the security rule, but I think it's so important, and it's such a common gap. I have yet to do, and I mean this literally, I have not done a single risk assessment where I have not found missing business associate agreements, vendors that they had no idea business associate agreements were required, and so on. We always find missing business associate agreements. Sometimes vendor relationships of years with no business associate agreement in place. Now, in some cases, it's just a clerical thing. Sometimes they can't find the BAA with their EHR vendor, right? I don't really worry about those very much. There probably is one or was one someplace. I don't worry about it too much when it's a vendor in the healthcare space. You trust that they know what they're doing and they meant to sign a BAA, so we hope. But it's not uncommon to get to a situation where they're using somebody who doesn't have a BAA, is not prepared to sign a BAA, doesn't understand what a BAA is, and when asked, outright refuses to sign a BAA. In one situation, it was a paper storage company. They had years of records there for many years, and the storage company vendor actually read the BAA and said, "I'm not signing this. This makes me liable for HIPAA." And we said, "Yeah, that's why we're asking you to sign it." And I'm dealing with a situation right now where a business associate has a subcontractor, and we've found out that the business associate doesn't have the BAA with their subcontractor as required. The subcontractor is not going to be prepared to do this. So here's my question, Sharon. These, to me, are impermissible disclosures. We're disclosing PHI to vendors in the absence of a business associate agreement. aren't these impermissible disclosures? Does this have to trigger our incident response policies? And could this trigger a report to the Department of Health and Human Services?
That's such a loaded question. I would certainly, whether you need to report it and whether it's considered an inappropriate disclosure is one thing. I would certainly recommend that if the vendor won't sign a BAA, find another vendor.
Sure. Absolutely. Although I do have one case where the provider said, we have acres of storage at this vendor, and the vendor doesn't have a BAA. It's basically a shed with a padlock. It's not document storage. It's not got any kind of security controls. And they're just going, how are we going to move all of this stuff? And so I don't know. But yes, ideally we want to at least get to a vendor and get a BAA in place. But what about those years when we were disclosing PHI?
Well, I think you'd have to do the risk assessment, right? And look at the risks and look at who that vendor was, what controls they had in place, whether there is any likelihood of improper disclosure, and just look at the whole situation. And recognize that, and I was going to say, recognize that this is a process, right? So you may discover that these situations are in place. You're showing good faith in trying to rectify those situations. So I would continue going down that process. I see many cases where the opposite happens, right? So people have, on the BA side, they've signed the agreement without doing the back end stuff. So yeah, technically, that's why I said that you've checked the box, but you're not the covered entity or the patient isn't any better protected because the business associate signed the agreement, but it doesn't have any security in the back end.
Mm-hmm. So do the incident risk assessment, follow the process.
That's what I would recommend.
So I'm Parsivir. How many incidents from a response perspective, you don't know what's transpired. You'll never know what's transpired. You don't even know the breach has taken place. So it's like the dog chasing its tail, right? Where will you start? Where will you end? That's my question. Because, I've like Michael, like you have developed some response plans. I've written manuals and volumes of this stuff. Besides actually implementing stuff, right? It's not that trivial, correct? And how are we going to find out what happened for 10 years ago? I mean, in today's world, people don't even know breaches happening under their eyes. They miss them. And it's only done after that. Breaches happen. They'll never know. Life will move on as moved on. It's not the good thing, but it's a fact. So my question I'm going to put right back here is, where do you start? Where do you end? Because there is no start and end to this at this point, right? Unless they need to rectify their ways. And that's the best hope we have, right? Or am I just make it too simple than it is?
I don't know. There's one thing that I think is going to be critical. So for example, in one case that I'm working with, it's an email filtering service provider. So they've been receiving every single email that the practice sends, and any email that has PHI has been received by this vendor and to provide filtering services. So they're receiving PHI. I mean, a critical thing is going to be to get documentation we're switching to a different provider and getting some kind of assurance from the previous vendor, for example, that data wasn't stored. I mean, maybe they're just a conduit, but
yeah, and I think when looking at all these situations, you're going to have to look at your organization's risk level, right? So in this particular example, I mean, I know, Michael, what you do. They're already doing the right thing that I brought you in to do an assessment. So is the customer comfortable with it starting from we go from here forward approach? And that may be a way to manage it, as opposed to saying, okay, we have to go back to 2003 when the privacy rule came into effect and go backwards. That will prevent them from moving forward. So you have to be realistic. And I agree with Michael in that case, in that situation.
Yeah. Great. Hey, thanks.
Yep, sure.
So
one more question while we're waiting.
Oh, good.
Are translators business associates? translators do patient translation during care. That would be a business associate. Is that right?
The relay services aren't, but I would think yes. If they're going to be storing the PHI, I think if they're sitting in the room, I would have to verify that. I don't know off the top of my head. If anyone else on the webinar knows, please send it out in the
Hey,
chat.
Sharon, it's Dina. I always have clients have their translation services sign a business associate agreement.
Great, thanks, Dina.
So do we have any other questions from anybody out there? If not, I want to thank Sharon for her expertise and her time, and for the comments from Michael and Pardiv. Thank you. And just a reminder that HIPAA does a very nice job of keeping track of BAAs for both business associates and covered entities. Easy to find, easy to track, and all in one place. So that's it for now. Without anything further from anybody in the audience, I think we can say goodbye. And thank you again for your attendance and your time.
And feel free to reach out with questions.
Yes. To anybody. We're always available for assistance and help, and we share a lot of information back and forth. So thanks again, Sharon.
Thank
Yes,
you.
thank you.
Thank
Great
you,
job.
HIPAA.